The trial procedure prescribed for warrant case is much more elaborate than that provided for a summon case. That provided for a summon case full stop. The classification into summon case and warrant case. The classification into summon case and warrant case also summon importance at the stage of the issuing process to the accused person to decide as to whether a summon or a warrant is to be issued to him in first instance. The first instance full stop in summon case, summon shall be issued, and in warrant case warrant may be issued. Function under the code. Function under the code. The main functionary exercising power and discharging duty under the code are 1. Police, number 2. Prosecutor, number 2. Prosecutor, number 3. Defense counsel, number 4. Magistrate and judge of the high court, and number 5. Prison authority, prison authority and correctional service personnel, correctional personnel service. Full stop. In next lecture the rule, prejudicial power and duty of each of these functionary shall be discussed. Functionary shall be discussed. Full stop. Main assessment, main segment of the criminal procedure. Main segment of the criminal procedure. While the general purpose of the criminal procedure is to provide a mechanism for the administration of the criminal law. Administration of the criminal law, it is object. Core object is to ensure for the accused a full and fair trial in accordance with the principle of the natural justice. Principle of the natural justice full stop. Therefore, the trial procedure become the pivotal part of any scheme of the criminal procedure. Full stop. Another important segment of the criminal procedure is investigation, which is the prosecutor of the trial procedure. Full stop. It include information as to the commission of any crime, detection and arrest, of the suspected offender, and collection of the evidence related to the commission of the offense. Commission of the offense, which may be consist of first the examination of the various person, 2. Search of place and exciser of things and document useful as evidence in the trial. Full stop. Investigation also include the process. Investigation also include the process whereby the case is brought before the court for trial. Full stop. The term investigation has been given a somewhat limited meaning when it is defined as including all of the proceeding for the collection of the evidence conducted by a police officer or by any private person authorized by the magistrate. Therefore, it would be considered more appropriate to describe this segment of the procedure as pre-trial procedure. हो गया pre-trial procedure. When the trial is concluded and the accused is found guilty or innocent, the trial procedure in fact come to an end. Full stop. However, the code envisages for sound reason, the review of the decision of the trial court by high court for the correcting error, if any such a decision. Full stop. In a sense, the review procedure is in extended trial procedure. Full stop. However, it is expedient to tread Expedient to thread. The review procedure has a separate segment of the criminal procedure. Separate segment of the criminal procedure, full stop. The process of the execution of the decision of the trial court and the review court is another important segment of the criminal procedure. Criminal criminal procedure, full stop. The code has formulated certain rule for the determination of the jurisdiction of the police and the court in respect of any offense under the investigation or trial, full stop. Has these rules are applicable both in the pre-trial procedure and trial procedure. Pre-trial procedure and trial procedure, they might be considered as forming in intermediate segment between the said two procedure, full stop. The code has been provision for the release on the bail of a person under arrest or detection pending the pre-trial trial and review proceeding. Full of these provisions are tended quite important, and it is expedient to the study him together. Thought do apply during pre-trial and trial and review proceeding. Full stop. These are main assessment of the criminal procedure. However, the code also deal with one prevention prevention of offense to main importance of the wave importance of the wife, children and parent, and three, public nuisance. These are the main segment of the criminal procedure. These are the main segment of the criminal procedure. However, the code also deal with one prevention of the offense, maintenance of the wave, maintenance of the wife, children and parent, and third is public nuisance. These provision can be studied separately as they do not really pertain to the mechanism for the administration of the criminal law. Also, these provisions are however helpful indirectly for achieving the main objective the administration of the criminal justice, and therefore they may be given their due importance. Given their due importance, the following table will show the above said main segment at a glance. Main segment of the criminal procedure. Main segment of the criminal procedure, pre-trial procedure, information regarding commission of offense, arrest, examination of person, search and excisor, and similar other aspect of the investigate process. 2. Jurisdiction of the police and court in respect of the investigation and trial of the offense. 3. Bail. 4. Trial procedure. Cognizance of the offense. Initiation of the proceeding. Attribute of the fair trial and other general provision regarding trial and charge type of the trial and judgment. Main segment of the criminal procedure. Review procedure. Defense appeal provision. Exercise of the inherent power of the court. 6. Execution of the final decision of the court. Execution of the final decision of the court. Other area covered by the code. A. Prevention of offense. B. Maintenance of the wife, children and parent. C. Public nuisance. हो गया public nuisance. पब्लिक नॉइसेंस हो गया, क्या हो गया? पब्लिक नॉइसेंस। पब्लिक नॉइसेंस हो गया, क्या हो गया? पब्लिक नॉइसेंस। पब्लिक नॉइसेंस हो गया, पब्लिक नॉइसेंस। फंक्शनरी अंडर द कोड। फंक्शनरी अंडर द कोड। द पुलिस ऑफ फोर्स। Police force is in instrument. Police force is in instrument for the prevention and detection of the crime. Prevention and detection of the crime. The police force is in instrument for the prevention and detection of the crime, and is established and enrolled by every state government. Every state government under the Police Act 1861 or under a state enacted replying the act of 1861. Full stop. In each state the Inspector General of Police. Inspector General of Police is in charge of the overall administration of the state police force. State police force. Inspector General of Inspector General of Police is in charge of the overall administration of the state police force. State police force हो गया, state police force. Whoever the administration of the police in every district west in the every district vast in the district superintendent of police. Was in the district superintendent of police under the general control and direction of the district magistrate. Direction of the district magistrate, who is usually the collector of the district. Full stop. The code offer specific power, for example power to make arrest, search, extra on the member of the police force who are enrolled as a police officer. Full stop. The police officer who are in the charge of the police station. Police officer who are in charge of the police station have been given wider power. Wider power as they are required by the code to play a pivotal role in the investigation and provision of a crime, but they do not have power to look into complaint which do not contain legation of the commission of the cognizable offense. Commission of the cognizable offense. Police officer superior in rank to in offenser, rank to in offer in charge of a police station can exercise the same power throughout of the local area to which they are appointed as may be exercised by such a station house officer within the limit of this station. Within the limit of this station, under section 177 and 178 of the code, police has wide jurisdiction. Police has wide jurisdiction, enabling him to inquire into a complaint which have been already been filed in another jurisdiction. File in another jurisdiction हो गया. The prosecutor. The prosecutor. A crime is a wrong not only against the individual victim but also against the state. Also against the state. Therefore, the state take upon itself, at least in case of the serious offense, the responsibility of the prosecuting the accused person. Responsibility of the prosecuting the accused person. Prosecutor. The prosecutor. The crime is a wrong. A crime is a wrong not only against the individual victim, but also against the state. A crime is a wrong not only against the individual victim, हो गया, but also against the state. Full stop. Therefore, the state take upon itself, at least in case of the serious offense. In case of the serious offense, the responsibility of the prosecuting the accused person. Prosecuting the accused person. Full stop. The central government and each state government have power to appoint prosecutor for conducting prosecution and other criminal proceeding. Another criminal